Late visual. I wish to mention item number 15. The writ petition, there are some mistakes. The impugn order has not been actually incorporated in the prayer list.
You want to withdraw?
To withdraw with a liberty.
Mr. Y.S. Counsel appearing to petition. That there is some mistakes which had kept in inadvertently, like to withdraw the same. Refile after making the same. Dismissed from withdraw. Item
Obliged.
15, 1-5.
What? Obliged.
Malab pending, malab matter, malab. Here, malab in this case, what is one? Both the petitions are pending. Respect of release of family pension, malab. It was last listed, malab 19 and 93. Sir, may come, malab the month of May.
May.
Obliged.
4th May.
What's it?
4th.
Obliged.
Admission matter, my lord, matter participation, my lord, petitioner is declared unfit in the medical ground in Central Armed Police Forces. Matter is ready for dismissal. Unfit of 2 matters.
How many matters?
2 matters.
Matters. 4th of May.
Obliged.
Your Lordship, extension item number 6. Some difficulties. Can we adjourn the matter order day?
Item 6, the request made on behalf. After next week.
That is Lordship. Also, I'd like to wait for listing of an alternate IA Lordship on Monday. Obliged.
IA for what correction?
Yes, Lordship.
Please, your Lordship. I beg to mention for listing a matter which has been listing on 10th November 25. Kindly allow for listing that. On
For
Monday.
what admission?
Admission, Lordship. Monday,
Monday.
yes, sir.
Monday you wanted, all right? Monday. 27.
May I please, your Lordship? Lordship, I beg to mention item number 40.
4.
40. 40.
4.
And the other 40, your Lordship. 6 on 8.
Item 40 on the request made by the council. Stands different. Listed after one.
Obliged.
May I please, your Lordship? Lordship, I beg to mention for listing a matter regarding selection and appointment of Gauhati, Lordship. It was last posted on 14th November 2015. Lordship, kindly fix the date.
Next week. 27.
My Lordship. So the petitioner side is item 17, Lordship. We have been very recently engaged as council correspondent, so some time to work with the file.
17, you are for the respondents.
Yes, Lordship, for this one.
Item 17 on the request made by the council. Stands referred, listed after 2 weeks.
Okay, Lordship.
Lordship, paying for listing of a petition on Monday, Lordship.
Monday. For what? Admission?
No, motion, Lordship.
Motion?
Yes, Lordship.
So in regards to item 30, the affidavit is going to be filed during the course of the day. I am praying that the matter will come up on Monday.
You have informed the other side.
Yes, sir.
Item 30, listed Monday. The request made by the standing council, submits that the applicability of fine. But why on Monday? Then you may like to file a reply. Yeah, listed after 2 weeks.
There is an interim, that is the reason. But instead transfer of.
All right, Monday.
Yeah, in Monday. In Monday,
Interim order passed early 27.
Supposed to apprise your Lordship of the payment of subsistence allowance. I have been given a
Payment of?
subsistence allowance, Lordship. So I have been informed that till March 2026, his subsistence allowance are clear. This is a snapshot from the Finance Assam portal.
He's already paid.
Right around 9:30 a.m. morning in the morning, my client has made a phone call. He did not receive the. Yesterday also he visited me, but the payment is not received.
What is the meaning of bill passed?
Lordship, it goes to the treasury and the treasury then transfers the amount to the account of the petitioner.
That's what I'm asking you. Bill passed indicates the date on which the amount is released.
That I cannot be sure of.
Then why are you making a submission that payment has been released?
Lordship, my telephonic instructions, they have told that till March 2026, all payments have been cleared.
But whoever has handed you this, where did you get this?
From the concerned, from the
So you get your inquiries and ask them whether the amount has been finally transferred to his account or not.
I've been told that regarding the month of April also, he is supposed to submit a non-engagement certificate, which he has not submitted yet.
That's already
No,
done.
forget April. Tell us about March, till March.
Till March, I've been told that everything is clear.
We want you to give us clear instructions in respect of this endorsement that bill passed on 9. What is the meaning of that?
Lordship, even I have been told that if the petitioner wants, he can log into the finance assam portal and he can see whether the amount has been credited to his account or not.
Give him the particulars. Give him the particulars. How
Lordship, that he will have to log in. We don't have the credentials.
So we are asking you questions. Every question you report, your answer is the question back. You give me this sheet of paper. I'm asking you what you have no answer. You are giving counter suggestion that he should go and log in. He's come to the court. You give clear instructions to say that yes, on this date the amount has been credited. Why can't your officers give that information to you?
Lordship, if I may suggest, the petitioner may also have.
You don't have to suggest, and even if you suggest, we are rejecting your suggestions outright. What is the difficulty of your officers giving clear instructions? What are they? Are they flying satellites? That it requires precision and half a second of information here and there is going to be a problem? What is this? Who is the officer who has given you this?
I received it from the accounts officer. Concerned keeping.
Who is your officer in Gauhati who is giving you, who is responsible for giving you this instruction?
No, Lordship, the subsistence allowance is to be paid from the development block.
All right, call your officer at 2 p.m.
I'll pay for some time then.
No time. Call him. Call him at 2 p.m. Call your commissioner at 2 p.m.
Is there
Enough of all this. We have given you enough time. You can't get instructions clearly to assist the court, and you are asking the petitioner to go and log in and find out for himself.
Can you come on Monday?
2 o'clock, you get instructions, or we are calling your commissioner. Whatever, we have given you time. It is up to you. You call, you obtain your instructions. Don't get your instructions. We are passing orders at 2 p.m.
Can it be on
Yes,
Monday?
no, 2 p.m. One more word, I'm imposing cost. Don't overindulge yourself. Don't misuse the indulgence given by the court. Yes, Mr. Bhagwati. Yeah, Mr. Monto is supposed
Yes, my
to
lord.
give.
Yes, already we have written letter. You have cleared.
Cleared him.
Yesterday, my lord. This is probably.
We show it to him.
No, my lord. No, actually, my lord.
If he is happy, we are happy.
That is after some Monday or.
I have done our part, my lord. This is now.
Why not?
Just for the department,
Why
they
photo
yet received the letter yesterday only. After 4, they will send it.
What's this
Because
is
before-
not an election related thing also. They are making it political.
So not political. The fact is that the officers of the state
All
will
have
be
been
involved in their duties.
Lordship, he has done, APSA has done their part. If I haven't gone through, Lordship. Transport Department.
You do one thing. You will have it on 29th. Get your instructions on 29th.
Lordship.
29th.
29th of April. Lordship, can I have a copy of this?
It's for him to see. You don't require the court permission.
I
We have already requested Mr. Mountain
Yes.
to hand over a copy. You see, on 6th of May, your answer will be that new government has come in, so officers have been transferred, not available, therefore further 2 weeks time. Uh, What problem? These are routine matters. You get instructions on 29th. Let us see what happens. You get clear instructions whether they have received the letter, when are they taking steps. 29th, Mr. Bhagavati?
My lord, no.
Based on 29th, as submitted by Mr. Mount to the Mount Council for the PSC, that
Earlier, kept in
The-
APS has been
the what was pending against the petition?
recommendation, my lord, recommendation in respect of petitioner was kept in APS.
The recommendation of the recommendation in respect of the petitioner was kept on hold by the PSC, certain allegations.
Now that has been,
which has been raised. What has been done?
that kept in APS order has been written.
APSC has in the meantime drawn earlier order passed in against the writ petitioner in respect of the petition, and accordingly the same State
That will be
Department,
kept in record.
State Department by communication dated MS MD Bora, Learned Standing Council Transport, submits that she has no instructions whether the copy has been received by the department. She prays for some time, requests the court to have the matter listed up for.
Okay, she says that she received it yesterday.
No,
No, no,
Shall
please,
they have issued yesterday
Sorry,
only.
sorry, Lord, sorry.
let the matter be listed on 29th of April, by which date? Or let it come on 6th, Mr.
Lordship, again, if a new government comes, suppose I say there are no new government come, then again things will start, Lordship, delayed.
All right,
Getting delayed.
29th of April.
What's of it?
Regarding some hardship allowances.
Risk and hardship.
Yes. Yes, 88 lordship, some things are pending lordship. Available is
Council
91, 94.
Page 91. For the respondent. Extra copy will be furnished in the period of 1 week. For pending appointment and compulsory ground was recommended by the DLC as well as by the SLC. And by the same recommendations, appointment of the commission. The recommendations have not been given effect. In spite of the recommendations by SLC on 2523, recommendations have not been given by same appointment as per the recommendation. Can you get instructions?
I think this will require another academic time.
Should notice returnable forwards, Mr. Bora. Respondent number 1,
3 and 5.
3,
I have to minor
5.
then
Mr. R for respondent number 2 and
4.
4.
Director.
Since the respondents are represented,
My name is not on the call.
respond registering take the name of Mr. D. Bora and Mr. R. or council will respond.
Second round of litigation lawsuit. Earlier, the petitioner was removed from service. Lordship, that order lordship will find at page 30 lordship. And except 3.
Then what happened?
Then lordship, the petitioner preferred an appeal, and the outcome of the appeal was not informed to the petitioner lordship, for which the petitioner approached this honorable court. And during pendency of the appeal, when the state respondent has filed their affidavit, it has come to the knowledge of the petitioner that he was already reinstated in service on 17/8/2019. That order will lordship will find at page 32, annexure 5.
You should notice today.
And lordship, petitioner has also preferred RTI applications that reply lordship will find at page 47, annexure 13.
Probably you should notice today heard.
And also during petitioner application, he was dismissed from service. The reinstated order was reviewed and he was dismissed from service. So petitioner had to withdraw that earlier application.
Now, did you file an appeal against the dismissal?
The lordship will give lordship pages to see the order passed by this honorable court at page 52, page 53 onwards. Lordship, the court is and while passing the dismissal order, the opportunity of hearing was not granted. Lordship.
So we are asking. There is an appellate provisions. You should go and file an appeal before under the statutes. Unless you give reasons why the appeal is not a efficacious remedy.
Because lordship, my responsibility, the impugn order lordship was passed during pendency of the writ petition. That way, after filing of their affidavit in opposition lordship.
But you withdrew this writ petition.
Actually, lordship, there was no submission on my part for withdrawal, but the court insists, so that's why I have to withdraw and go to file a fresh lordship.
So the question would be, there is an appellate forum. Why have you not approached the appellate forum? Statutory appeal is there.
Some time when we granted lordship, in the meantime, I will approach the
No, then we'll permit you to withdraw this and file an appeal.
Yes, lordship.
Third counsel for party, counsel for Chennai has challenged the order of dismissal passed by the director general of police. When was the order passed? 11/9.
Yes, lordship. 11/9/25, and if it was filed on 9/9/2025 in the court.
Earlier approach the report by filing WPC 949 of 25, seeking a direction for area salary for reinstating the petition. So, pendency, action, accordingly, dismissal. Subsequently, as to why the statutory appeal was not heard. Some statutory permitted to people by withdrawing the petition, but support again, grievances are not request. Counsel for the state and its and Bhattacharya. Dismissed as not pressed, but or withdrawn. Technically, exam servicing discipline 1964. Limitation as the petition was personally displayed before this court. According to stands disposed.
May I pay the appeal may dispose of what is stipulated figure of-
First, you have to file it.
Yes, yes.
File it. If not dispose, attempt will be made to dispose of the appeal. If the appeal is filed, within how much time you require?
10
File the
days,
appeal.
maximum 10 days.
If the appeal is filed within 2 weeks from today, the appellate authority will attempt to dispose of the appeal. 60 days. Needless to say, petitioner grievances are not redressed. There will be no bar for the petitioner to approach this court.
Deeply amended. I was initially appointed as a Masterul worker subsequently in 1990 to upgrade the post of worker section assistant. And like regular, I getting regular scale of pay with all benefits. But my service not been regularized. APC recommended my case for regularization by minus meeting dated lawsuits 27/5/5, page 34 lawsuit, not taken up. And I am going to submit on 34 to 23 lawsuit, page 25 lawsuit minus the page 34. 34 lawsuit, second paragraph, page 35 lawsuit, after their discussion. Observing all documents by all members of the PCPW, the proposal of the member secretary CPWD was accepted and recommended and suggested 6 numbers of what the section is 10 of the regulation.
He's praying for what? Regularization.
Paying for paying for his case is
Regularization.
recommended in since.
Recommended.
Lordship, I've talked to the department since after going through the, we have come to know his retirement work. Lordship, they have sent one communication, although it is backdated, Lordship, which I may have received it last night, no? Let this matter be taken up on Tuesday, Lordship, since it's diary. Tomorrow is, of course, Saturday. So Monday may not be possible. I'll come up with instruction on Tuesday night.
Wednesday, 21 Tuesday.
He's retiring on
On
34.
34. Yes.
He was already 28 years.
Why were you waiting for so long?
Yes, since my department recommended waiting and waiting for their considerable.
The petitioner before the court is praying for regularization of its services as what charge section assistant, which he has been rendering since what, 19, since his original date of entry in the service on 3/07/1992 under the office of the executive engineer PW Roads. Petitioner seeks a direction to the respondent authorities to regularize the services as his case has been already under, his case is already under consideration. And however, it is apprehended that since he is superannuating on
34.
30/04 2026, his case may not be considered for MSE, yeah, standing counsel UTC has placed before the court communication received from the Solpur RNB division in Solpur that petitioner's case is under active consideration. Submitted that she would like to complete her instructions in this regard and therefore seeks liberty for the matter to be apprised the court on 29,
28.
28,
28.
28. Accordingly, list this matter again on 28. Mr. Radhor appears for respondent one. Counsel for petitioner will serve sufficient extra copies to the respondent counsel during the course of the court. Online.
The petitioner has retired from service as deputy manager Artfed on 13/6/2018 and was re-employed for 3 years. Subsequently, the condition that gratuity and leave encashment was kept as security and that will be released after completion of the contractual period. My lord, hereafter I have submitted number of representations to the authorities for release of my gratuity and leave encashment.
Yes, PWD get instruction.
No, my lord, this is Artfed.
Oh, sorry, Artfed.
Artfed, my lord, notice, they don't have a count.
1, 2, 3, 4.
Third counsel for petitioner. Parties. Should notice that represents all the
1 and 2, my lord.
1 and 2.
Rest, my lord, this is the corporation, but cooperative thing, my lord.
1 and 2. Therefore, notices in respect of 1 and 2 are waived, extra copies. Steps on respondent 3, 4, 5. I speed post. I can be listed there.
My lord, my name will be shown in the court. For handloom, I am appearing, my lord, 1 and 2.
It is not shown here, standing counsel.
No, my lord, not shown.
Registry will reflect the name of standing counsel. What is that? Handloom and textile.
Textile.
Textile. Yes.
Very small matter, my lord. Relates to non-grant of one financial upgradation under the MACP scheme. Look, my appointment as lecturer in violin of the State College of Music was regularized with effect from 31/10/1996. So therefore, I completed 10 years on 30th October 2006 and thereafter 20 years on 30th October 2016. One financial upgradation I got in 2011, first with effect from 1st January.
You're still in service.
No, man. I have retired. In 2018, there was an advertisement for the post of principal. I applied by direct recruitment. I got appointed as principal.
In?
As principal
In where?
in the state college of building. By direct recruitment, it was a separate advertisement. I applied for the post. Thereafter, I retired as principal.
This MSCP you are claiming for the services rendered as a lecturer
As lecturer.
in the same
In
institution.
2016, I completed 20 years. Till 2018, I continued as lecturer.
Let notice go.
Yes.
Heard Mr. T. Swami. Mr. R.
So 1, 2, 3, 5, 6.
Respondent 1, 3, 5, and 6. Respective respondent 1, 2, 5, and 6 times B. However, extra copies will be furnished within a period of 1 week. Respondent. 1, 2, 3, 4, 5, and 6. Which is a way. Steps on respondent 7 by speed post within 1 week from now. 7 is the petitioner himself.
No.
No.
He retired from now. The incumbent is the.
No, no, you said you are working.
I have retired as principal.
Or you have
2020.
retired. Let the respondent instructions and file necessary affidavit. So, claim of financial obligation. Petitioner under the Modified Assured Career Progression Scheme, MACPS, upon completion of 20 years of service. Their promotion. It's not even great petition. Just after return.
Termination from service, my lord.
Appeals.
Appeal also filed, that was also rejected. In fact, my lord, it was at the appellate stage where they did the examination and cross-examination of witness. Direct violation of Rule 9. Right?
Inquiry report submitted.
Inquiry report submitted, my lord. When 28/11/2013, they serve a show cause. And on 3/2/2024, they appointed an inquiry officer. They asked me to come before this on 7/3. I go there, they make me stand outside and they prepare the inquiry report. They impose the penalty. And when I point out all these things in the appeal, then they ask me to cross-examine. If your lordship kindly sees page, penalty is 19/6/2025 and that letter is at page 73, my lord. Page 73. So, my lord, if your lordship sees 13th October 2025, the date at the top, and they write a letter to me, and in the subject they say, appearance for hearing and cross-examination. In pursuance of the above referred case, you are hereby directed to appear before the duly constituted inquiry committee for the purpose of hearing and cross-examination on 12/11/2025. So they cross-examine me after they have imposed penalty.
One and two.
Only two.
Huh?
Seva, my lord.
What about one?
One for both. One and two. For both.
One and two. Therefore, this is the way it's performed. Your is order of dismissal.
Dismissal. And as well as the appellate order.
Compulsory retirement.
Compulsory.
As well as the appellate order. Both. Of like diploma.
Yes. Appeal file.
Appeal also filed and also check.
This is under what?
CRPF.
CRP. Why is Mr. Sutyate?
No, minor, response number 6. Director of Board of Secretary, there is no director. Until it is corrected, as a secretary, SF, I cannot accept this on behalf of response number 6.
But you already entered appeal.
No, they have a copy, that's why I have come.
Filing. Respondents 1 to 5. Strategies for clear evidence of secondary education.
Assam school education, now Assam state school education. Now, Assam state education.
Mr. Suti, however, submits that there is no board of secondary education as of date. Has been renomenclatured as Assam
State school education board.
Assam State School Education
SF,
Board, represented by
by secretary.
Secretary. So, such circumstances, then under such circumstances, petitioner will take steps to file amended post title, rectifying the name, rectifying the particulars of respondent 6 by making the necessary corrections. Let this amended course title be filed within a period of 1 week. Thereafter, steps on the registry. Matter will be listed after the return of the extra copy will be furnished within 1 week.
Apply.
My lord, that the petitioner is agreed to the quantum of pension, my lord. The length of service of the petitioner.
Yes.
Lordship, an affidavit is being filed by 30 in one of the matters, similarly stated matter. So,
I heard that the council for party should be the best. One, two, three,
1, 4 and
4.
1, 4 and 6.
1, 4, and 6. Mr. CPS Borua for when 5. MS A Boda Group for respondent number. Respondent number. Deputy 1.
We apply it.
So this matter pertains to non-payment of gratuity. The employee has resigned after putting 18 years of service. The lordship of the matters has already held that the employer cannot deny the payment gratuity to the employee if he has worked more than 5 years and so. For a strange reason, they have adopted 6 years rule. Now they my lord,
For today, we'll issue notice. Heard council for the party. Pass. Just after the return. You produce the judgment on the next day.
yes, sir, I have.
Because is it reported or not reported?
Not reported, I guess, my lord, recently.
What is the number, petition number?
WBC number 3534
3534
of 2024.
order.
The I have supplied the copy, order dated 3/6/2025.
We take it up next week. Yes, after return.
Much obliged.
May petitioner lordship, my lord. My lord, here, my lord, the inquiry report has cleansed the petitioner from the charges, my lord. Inquiry report page 81, my lord. And the relevant portion, lordship, the page 86. No evidence of taking money found, my lord. And thereby the petitioner the charges were not proved against the page 86 charges. Now, my lord, while the charges are not proved, then disagreement note they have, my lord, accepted, my lord. On the basis of the disagreement note, my lord, now they call me for page 88, why punishment should not be imposed. And accordingly, they impose the punishment at page 102, my lord. Stoppage of one increment. However, this is a minor punishment. But my submission is that, my lord, that while acting upon on a disagreement note, my lord, to give the views of the petitioner, to give a chance that why you should not proceed with the disagreement note, that scope is to be given to the delinquent petitioner. Without giving that, my lord, they cannot accept the disagreement note.
Where is the disagreement note?
Yes. Page, my lord, 87. In fact, the last paragraph, confession admission made by delinquent before a person, the authority is admissible. The confession admission made whereon the circumstances matter sufficient to show that the above six charges, so and so proof beyond. Now, prior to that, my lord, so for this confession is concerned, this is not before the regular inquiry. They have accepted a confession in the preliminary inquiry. So, on the basis of preliminary, since you cannot impose punishment, this is for your satisfaction whether you should go for a regular inquiry or not. So, if this confession is made before the inquiry officer, as per which has been appointed as per the rule after issuance of the search memo, that is another thing. Because preliminary inquiry report, my lord, on the basis of preliminary inquiry report, no punishment can be imposed.
So, but this is given to you, paragraph, page 88.
Page 88, my lord, they are furnished. After accepting, they furnish the copy and they say why, my lord, punishment should not be imposed.
Then?
For accepting the punishment. Now, my lord, requirement of law, if my lord, that Ram Kishan case, my lord, 1995 6 SCC 157, my lord, there it said, my lord, that before accepting the disagreement note, under which what are the heads you want to disagree, you furnish to the delinquent officer. And thereafter, because you give a chance to him, why the department should not go with the disagreement note and why the inquiry report is correct.
No, but you have given a reply.
No, my lord, this is after accepting the.
Have you raised this issue before that the disagreement note is not given to us, given to you?
My lord,
In your reply at page 90,
yes,
this is your reply, isn't it?
yes.
Did you raise this issue that these specific areas of disagreement are not communicated?
My lord, yes. My lord,
Not raised.
but this is the requirement of law, my lord. That
No, but the
that's
requirement
correct.
of law is for you
Petitioner
to,
himself,
you to urge EDP to the requirement of law.
the
You did not raise it.
petitioner, my lord, perhaps is not know about the law, my lord. So on this point, my case is that, my lord, Ram Kishan case, and that has been, my lord, in the particular case of the Honorable High Court also accepted that, my lord, this proposition that para 10 of the
Maybe
Ram
we
Kishan
should
case,
discuss after returnable date we'll hear.
my lord. One of since that in order,
My lord, it's a order of 2023, it's challenging it in 26. When leaving aside the legal issue,
I file appeal, they have now rejected the appeal.
That is also challenged here. Appeal is also challenged here.
I don't see it.
Appeal, I filed, my lord, appeal, yes. Appeal, they have rejected.
Are
Prayers
you
are page number
challenging
30.
the rejection order on the appeal?
My lord.
Right, heard Mr. B.K. Das, come. Mr. K.P. Pathak, non-standing counsel, APDCL. Is it APDCL?
Yes,
Yes.
Petitioner is agreed by the order of dismissal. Sorry. The order of punishment imposed by the disciplinary authority as also the rejection of the appeal.
my lord, I'm sorry, I do not see the rejection order being challenged.
Except
Please,
the
this is
disagreement
the
note I
copy
have
which has been
sent.
served to me, that prayer is not.
Disagreement note.
Yes, disagreement.
Appeal order has not been
Primary.
challenged.
What is 27/6/23?
That is the order inflicting penalty.
Yes.
The appeal order has not been challenged.
The disciplinary authority order. Appellate note. Petitioner agreed that this order of dismissal is contrary to the law laid down by the apex court. As copy of the disagreement, as the grounds of disagreement were never furnished before the punishment. Represent.
Stop the return. Just one correction. Before accepting the disagreement, my case is that before accepting the disagreement, you said that the grounds for disagreement have not been furnished. My grounds for disagreement have not been furnished before accepting the disagreement. That was fine. Obligation.
My lord, the present petitioners are the parents of that Procedural Bourbon, who was an RPF and working under the NFLA Maligaon, and their branch office was at Alipurdar Junction. He died a premature death while he was on duty back. Just after his death, the restaurant number 6, who is our daughter-in-law, and restaurant number 7, who is our grandson, they immediately went to their house and thereafter went to Alipurdar Junction, and they claimed every benefit due to her husband, their father, and without informing us. We had communicated with the restaurant number 6, but she is not receiving our calls. Then we went to Alipurdar and came to know that she claims every benefits of Biswajit Burman. And we are
Under what provision are you claiming it?
my lord, as per section 8 and 10 of the Hindu Marriage Act, my lord, the husband, the parents are also first class legally.
This pension, he's
Not
an
only
employee.
pension, man.
He's an employee of the railways.
Yes.
Pension is to be given in terms of the
No,
rules.
not only your pension, there are so many things, gratuity, leave encashment, DCRG, and also due to sudden death, 75,000 rupees is given by the railway as an aggregate amount. So there are so many, I think it will be more than 60 lakhs. But with the all parents, we have also some shares. In a similar case, my lord, it was not in railway department, it was the state department. When the daughter-in-law tried to take everything, your High Court interfered, and some amount has been given to the all parents. That is, my lord, actually, this is case number, WBC number 2639, 2022. Hemlata Das versus State of Assam and others. Order dated 27/3/20. So, my lord, we are not for all. We are only 27/3/24.
Where is that order?
I explained to you, but that is there, my lord. My only prayer is, my lord, at this stage, the entire amount may not be disbursed to the restaurant number 6 with your daughter-in-law, and let the matter be heard on merit. Let the notice go and entire order may not be.
Order.
Case number WBC number 2639/22. Hemlata Das versus Mr. Vasan. Order dated 27th. And the pension is also.
Respondents 1, 2, 3, 4, 5.
One,
1 to 5. 1 to
only one, your lordship, for Union of India.
what about railways?
Elders also I am saying, lordship, not.
1 to 5.
You have not been served with a copy.
The
No, your
copy is
lordship.
served.
Huh?
It's a big. They submit to be how it is done by.
5. This is in respect of the following 1 to 5. Okay, extra copy will be furnished within a period of 1 to 5. Steps on respondent 7 and 8 by speed post.
8, 6 and 7. 6 and 7. 6 is the daughter-in-law, 7 is the grandson.
This is an order passed on consent. Judgment you are relying on, order.
Earlier there is objection, but thereafter court came to finding you do something
But there
otherwise.
is no finding that you are otherwise entitled in terms of law.
Self-fair motion. But if the entire amount is taken with the whole brother, we will be on a treatment. We are dependent upon the income of our son.
Just after you can read it.
No, this is a very serious case. Here the husband took the interview of wife. And the wife is the respondent number 8. And there is the order, they did not carry out the order of the normal court and partially produced the record. The main thing was signatures of the husband is there as invigilator, and he examined the papers of his own wife and gave some marks, and my marks were deducted. It is very. This is the last order, last part. Due to this colorable action, my lord, I did not get promotion as UDA. Part is the assistant, and his wife has got the promotion. Both are working in the same water resource department, same office.
Any instruction?
Yes, my lord, I have got the records. Actually, my lord, the submission, the opening line, that husband took the interview of wife is completely incorrect, my lord. I have gone through the records, my lord. A committee is formed, selection committee. Eventually, my lord, when she appeared for the written test, that day, husband was a assistant, senior assistant working in the water resource department. He also had it as invigilator. That's all. He was present in the vicinity when his wife appeared for
The
exam.
vigilator of the
No, nothing,
examination
my
hall.
lord, nothing. I have got the records, my lord. There are, my lord, the answer script were to be evaluated by the assistant engineers and junior engineers of the department. And selection committee was there. Interview also was conducted by, my lord, one ACS officer. All these are blatant lie.
Sir,
Records are there, my lord, with me.
my lord, my
And
deliciousness.
I have also got the answer scripts where the allegation is that I have not been given the marks and somebody else has been given marks for that question. I have gone through that answer, man. I don't think that it is incorrect to say, I mean, that they have not given any marks. I go through the answer.
Answer script.
Answer scripts.
I won't take your lordship, but there is the allegation is that there is no marks has been given for this answer. What answer?
So first, show us that allegation is that there was an interview by the husband.
No.
That
This is the report, madam.
flag mark the relevant pages. What is this yellow envelope?
Madam. This is the answer.
Answer scripts.
Right.
Have you filed your affidavit?
Yes, they have filed affidavit, but affidavit, these things, they did not bring.
You bring all these in the affidavit and support it by the records, then it becomes easier, so that they also get an opportunity to rebut.
They have filed affidavit, these are
These
the
are
new
not in
production.
production.
not
These
the
are all
new-
records.
New inventions by them. And kindly see page 59.
No, we wanted to give you an opportunity to rebut their claims that the allegations made by you were incorrect in the basis of the records. Now, there are two ways to do it. Either you see the records, or better way would be to permit them to bring it on record by way of an affidavit, so that these allegations can rebut it if you want.
There are allegations in the institution itself. And after going through that, they find affidavit. But in the affidavit, they did not bring all these things. These are the new things.
But the records are before us, or we go by the records, that's it. If we examine the records and pass an order, then you don't get an opportunity to rebut, Mr. Mahmood.
Short that I have been deprived from my promotion due to illegal intervention of person number 7 upon
In deference to the earlier order dated so and so, the respondent authorities have produced the original records and the answer sheets. Court, counsel for the respondent strenuously submits on the basis of the reports that the level against the department. Correct? Cannot be lied by the reports. The records do not reveal that the respondent number 8 was the husband.
8 is the wife.
Wife.
7 is
The respondent number 7, who was an employee of the department, was a member of the selection committee, and or an invigilator during the examination, or an invigilator in the examination hall, where private respondent number 8 was also attending. The department counsel further contends that the allegation that appropriate marks were not allotted is also belied by the records. The answer sheets do not reveal the lesser marks. Department counsel, however, submits that all these developments are not specifically dealt with in the affidavit filed on behalf of the department. She submits that is permitted to write a detailed affidavit, specific reference, some of the reports. They're made. wherever necessary are required so that petitioner but by which date respondents will file their affidavit, additional affidavit to advise. It is made clear that the respondent department will endeavor to file their affidavits within the time permitted by the court. Please accordingly after 2 weeks, please file it within 2 weeks. Let's begin on 15th of May.
Next.
Let's file the affidavit. And
we have received his pension proposal from the office last work, he worked there. They will be forwarding it to the state government. ECCF is in receipt of the.
how many months or years will it require?
No, this is a process, madam. It's almost in a logical end, madam. Because
Process is going on very snail speed. Order was of 25th of Feb,
No,
5th of
madam.
February 2025. 1 year has gone by. It's still going on.
There is no application seeking enlargement of time.
madam, that I understand, madam. But we are trying to get this, madam.
We'll issue notice in contempt. As to why
Time being, madam,
proceedings-
madam, and hold it, madam, because this is going on.
What is this going
Last
on?
order, my lord, say the person who's called to sign a few papers, he goes there, he signs, and then it is going on, my lord.
So going on is not an answer. You have to give
lord-
specific dates.
Specific date, today we'll be forwarding it to the state government, my lord. Make sure, my lord, it goes to the, in a fast pace, my lord, so it goes to the agent.
Reference to the earlier orders passed, Mr. B. DO, and council, standing council, forest department, submits that the proposal pension has been received. The office of the CCF and HOF. And during the course of the
Madam.
day, the same shall be forwarded to
The government, madam.
government as in
The
secretary,
first department,
secretary,
secretary.
secretary, Department of Forest, whereafter papers will be forwarded, proposal will be forwarded. Submits that certain steps are being taken by the department so that direction contained in the order they could by the jobs. Mr. Parameter Nath, the other end, submits that more than a year has passed. Which the order passed in WPC so and so not be complied with. Considering the submissions made, sport permits further 3 weeks time to ensure that the directions contained in the order passed in the matter be listed on 15th of May.
Well,
it is made clear that if directions contained in the order complied with, pension proceedings under one where you contempt of court sects, Gauhati High Court rules. Based on 15. Yes. Yes. Submits that. Right. File course title. Course title will be file. So here the council for the respondent number 12. Here's the respondent number 12. What about other respondents? The CTS Guru appears to respond. One and two.
5, 5,
Huh?
7, 5, 6, 7,
All the respondents. 1, 2,
except 9 and 10.
1, 2,
5, 6, 7,
5, 6, 7, 8,
and 11.
and 11. Respondents are permitted to. You are Mr. P. Sogia for respondent 11. 12. 12. This is for what? Pension? Pension. It's the first wife? I'm the first. So what interim order is granted here? But their allegation is that one girl, the second wife, she is the major minor. But as per the NOK, she is the major, and they are saying that she is minor. The petitioner. Minor. Petitioner is the minor girl. Minor girl. That's what they are putting. And on the basis of the death NOK, department equity pension. Pension to whom? The petitioner. To the first wife. That is your client. Minor. Now they are coming before this Honorable Court, for rectification of that order, what interim order is passed? 50%, 50% still, 50% allowed to withdraw. You are not filing, this was passed ex parte. This was passed ex parte. Matter be listed after 3 weeks. The respondent may complete the instructions and file necessary affidavit. Order passed earlier will complete. That's
Point involved that whether this memorandum of annexure at page 23.
yes.
Whether this 23 clause 3B1 is applicable to family pensioner or not. Kindly see the
Yes. Yes, yes.
page 23, my lord.
Yes.
Page 23, this office memorandum,
Clause.
paragraph 1, first kindly see. This order shall apply to all pensioner, family pensioner. Proceed, Bode.
Oh.
Now, this office memorandum contains paragraph 3, kindly see. Clause 3, consolidated division of pension oblique family pension is applicable. A is the calculation and B is the non-obstancy clause, on the basis of which not less than 50% of the minimum pay band in the grade pay is to be given, whichever is higher. If suppose 3B is higher, then this 3B will be applicable, or 3A. If 3A is higher, 3A is applicable. in case of family pensioner also. Now, while implementing authority, it has come to their conclusion that 3B plus 3B is not only applicable to the pensioner, not to the family pensioner. This was their confusion. It is not applicable to the case of family pensioner. Now, that confusion, my lord, has been clarified by the government of Assam in clarification at page 5, my lord. Page 30, annexure 5.
But 30 or 29?
Annexure 5.
Annexure 5.
Yes. Annexure 5. Can you see the letter number 88/2010, so and so dated 7th August, Lordship got it.
Yes.
Now, this from the secretary to the government of Assam and written to all accountant general, all the managers of the bank, regional manager, general manager, all. Now, kindly see the contents. Consequent upon the government decision on the recommendation of the Assam Pay Commission 2008, announced under government resolution number so and so, as published in the extraordinary issue so and so, regarding the regulation, revision of pension, family pension in respect of pre-11-2006 pensioner, family pensioner. I am directed to say that government in the PPG department have already issued necessary office memorandum and communicated to the concerned so and so. It has come to the notice of the government that dispute has arisen in the mind of some implementing authority as to the applicability of 3B1 of office memorandum in connection with the fixation of division of pension pre-11-2006 pensioner / family pensioner, causing confusion in disposing of the pension cases of concerned pensioners, whose cases are governed as per Assam Service Pensions Rules 1969. Now, the concurrence has been taken while reading the finance PRU department was consulted and department height under so and so dated so and so has further clarified that matter has provision contained in 3B1 of office memorandum number so and so appears to be clear and is in order. In view of the above, you are requested to take account of ready reckoner and the provision of 3B1 of OM dated so and so while fixing pension / family pension of pre-11-2006 pensioner. Now, after this, my lord, again, same confusion they have raised by the implementing authority. Then one applicant, one person, my lord, Gulu Borua, who has also filed a writ petition, my lord, before this honorable court, and that judgment, my lord, I have already supplied earlier. This confusion, WPC 4928 of 2015, my lord. One judgment, there is one judgment.
Yes, yes. Very good.
Now, by this said judgment, this honorable court held that 3B1 is applicable to the case of family pensioner also. This was the decision. It was decided on, my lord, kindly see 33/2017. Lordship got it?
Yes.
33/17, and the government clarification also of 7th August 2000, my lord, page 30.
Yes.
Date is important and issued by the Secretary to the Government of Assam. And after passing of this judgment, again same issue has been raised by the State Bank Authority also. There was another writ petition has been filed by one Vijaya Goswami and others, my lord.
What is the view of the department?
Department now, the department is again come up. You kindly see the affidavit filed by the AG, my lord.
No, in terms of which rule according to them.
Yeah.
Under which rule you are not entitled?
No, the government is not saying that we are not entitled.
Huh?
Now the AG and the bank authority are obstructing to implement the same manner. How they are obstructing, my lord? Kindly see the AG filed in one affidavit, my lord. This obstruction have come from the AG as well as from the bank authority. Because in case of past pensioner, drawing and disbursing authority is the bank, and any confusion is arise in the they can take government decision. Kindly, lordship got it?
Hmm.
Page 83, kindly. Running page.
Yes.
Yes. Now, kindly see this date, 24th August 2017. One Joint Secretary Government of Assam, lordship, wrote a letter to the Accountant General rectifying the, my lord, with reference to subject cited above. I am directed to say that pension and public given so and so issued clarification applicability of clause 3B1 OM dated so and so, dated so and so, fight so and so, dated so and so. This OM I have read out, my lord. It has come to the notice of the government. Despite clarification, there still appears some confusion regarding applicability of 3B1 of clause so and so with so and so. NSS once again clarified 3B1B is to be taken into account only in case of fixation of superannuation pension. It is not applicable in case of fixation of.
So what is the objection of the AG?
This is the objection.
Where, in which paragraph?
83, my lord.
No, in which paragraph of the affidavit?
Affidavit. At page, my lord, running page, my lord, 71, my lord.
Yes, AG.
Lordship, as per the clarification from the PPG department in
Yeah.
page 83, it is clearly stated in para third, second line. As such, it is once again clarified that the clause 3B1 is to be taken into account only in case of fixation of superannuation pension of pre-1126 pensioners. It is not applicable in case of fixation of family pension of pre-11.
You are reading from which paragraph?
Page 83, my lord.
Page 83, Lordship.
83. No, we are asking you from your affidavit. Where have you made this amendment?
Lordship, page 71, third paragraph. The Pension and Public Grievances Department Dispur has clarified by letter number so and so dated 24/8/2017 that the clause 3B1 is to be taken into account only in case of fixation of superannuation pension of pre-2006 pensioners, and it is not applicable in case of fixation of family pension of pre-11.
Where is that PPG department's letter?
Lordship, page 83.
PPG department, Assam,
Lordship.
Government of Assam.
Okay.
My lord, kindly see the letter written by who has clarified it. This is important. And this clarification has made with respect to Annexure 5, which I have read out. And in between, my lord, this issue has been raised before this honorable court, and honorable court interfere with that the decision, this view.
By which judgment? Budu Hazarika.
Bulu Burua and
Bulu Burua.
as well as subsequent judgment also by the Vijaya Goswami also.
Wait, show us in Budu Burua where it has been interfered with.
My lord, kindly see paragraph 10. A bare perusal of the extract demonstrated clause 3B1 is to be taken into account while fixation of family pension in respect of pre-11-2006 pensioner. It is apparent that United Bank of India, here is the PNB, earlier it was United Bank, now it is PNB, had not taken into account clause 3B1 while undertaking exercise of revision of family pension of the petitioner. In that view of the matter, the respondent bank is directed to take into account of 3B1 for the purpose of fixation of family pension as expeditiously as possible and any rate within so and so. Now, after passing of the judgment,
This one joint secretary has written one letter. Then thereafter also,
You come back to 3B1.
3B1. The pension, family pension. The pension, family pension,
3B1.
3B1.
Page number
3B1, page 26.
26.
There are two subsequent. Earlier, they have said that 2006, it is, my lord, at page 23.
Yes.
3B1. 3 is the consolidated, division of pension, family pension. Now 3B, above computation, that means 3B, 3A. Above computation is the subject to the following condition. The revised basic pension in no case shall be lower than the 50% of the sum of minimum of pay in the pay band and grade pay thereon corresponding to the pre-revised pay scale from which the pensioner had retired. Pension for the purpose of this calculation will be include commuted portion. This is not required. Next, payment for revision pension shall be subject to exclusion of commuted, not required.
So according to them, it is not applicable to family pension.
According to them. And this issue.
But the 3 itself contains family pension. And
Yes, 3 itself contains family pension. Not only this, my lord, 3. 1 also, finally see 1. These orders shall apply to all pensioner, family pensioner. And this is in pursuant to the, my lord, the decision was by the Assam Pay Commission 2008. It is clear. It is in respect of pensioner as well as family pensioner.
Yes.
We have done the calculation on the basis of the clarification which was been issued by PPG, where it is specifically written that it is not applicable in case of fixation of family pension of pre-2006
Who's
pensioner.
for PPG? Who's for PPG?
Judgment of there some one paragraph from one paragraph I paragraph.
Right.
The learned counsel for the SBI draw the attention. This judgment was passed in 2018. Draw attention of the court to the communication made by the Office of the Principal Accountant General Assam on 26/8/2013, by which the SBI was instructed that the revision of family pension in respect of employee of state government, family pension is to be made on the basis of clause 3A of OM dated so and so, and on the basis of ready reckoner. Division of family pension as clause 3B was not applicable to family pensioner as the OM has not allowed the same. He therefore submit that it was on the basis of that calculation as per the new revised pension was made. At this stage, the learned counsel for the petitioner has submit that similar identical matter wherein the disbursing authority concerned was United Bank of India, this court held that 3B1 OM so and so would be applicable to family pensioner referred made by so and so. Then next, kindly see next paragraph 9. It appears that there was a confusion.
Yes.
There was a confusion with regard to fixation of revision pension in respect of pre-2006 pensioner, family pensioner, and to dispel the misgiving and to clarify the intents of the office memorandum dated so and so, the secretary to the government of Assam, pension and public grievance issued a letter so and so to the respondent number 4, as well as among all other regional manager United Bank of India
Central so and so. In the said letter, it was noted as follows. It has come to the notice of the government that dispute has arisen in minds of some implementing authority as to the applicability of 3B1 of OM concerned with the fixation of revised pension of pre-so-and-so pensioner, family pensioner, causing confusion in disposing of the pension cases of concerned pensioner, whose cases are governed as per Assam Public so-and-so, Assam Finance, PRU department was consulted with the department right under so-and-so and FPC so-and-so dated so-and-so and so-and-so was further clarified that matter has mattered that the provision contained in 3B1 of OM so-and-so appears to be clear and it is in order. In view of the above, you are requested to take the account of the ready reckoner so-and-so. Now, paragraph 10, a perusal of the extract demonstrated clause 3B1.
Well, we have seen that.
Yes.
We have seen that.
Now,
Tell us,
paragraph
Mr.
12
Counsel
was
for PPC, what has happened?
interference.
There are two judgments saying that it is to be applied. Why are you giving further clarification without any reference to the judgments?
And that by the joint secretary one.
Basically, lots of the clarification is in regard to lots of this P116 lots in regard to superannuation pension and others, and our family pension is not agreed. Based on this, we have written one letter to them, to the accountant general. And so, as we have written a letter to the
We are asking you a question in,
that
in one
clarification.
direction. You
No,
are
no,
giving
no,
reply
but
from the other
I'm
direction.
coming to the point, Joseph.
Come to the point straight away.
That
The
clarification.
question is, in view of two judgments of this court, how can the people, without taking note of the judgment, give a contra opinion?
In fact, Lordship, I have seek one clarification from the PPC department on dated Lordship 23/2026. That clarification I have not received.
Who is the call your director, commissioner, whoever is there?
So one chance will be given to them, Lordship.
Call him at 2 p.m. What one chance? We are sitting here repeatedly dealing with matters. Why can't they give you clarification? Why can't they give you clarification? You get it at 2 p.m. or we are calling your commissioner, director, whoever is there. What's the difficulty in getting a clarification? There are two judgments. These are binding. And they give a opinion which is contrary to the judgment without any reference.
And by the incompetent authority.
In fact, Lordship, on the last day, they have given one instruction to me that Lordship, basically, we doesn't, although these OMs are from our side, we doesn't deal with that. GAD is the appropriate authority because the person was working under GAD. That was the instruction we had. It was sent to me.
Who has issued the OMs?
OM is under the personal, this pension, pension and public.
How can they say it is not applicable? Who has given you that instruction?
Their instruction is from the base.
Therefore, call him at 2 p.m.
Is from one Lordship.
You get instructions or call him at 2 p.m. We are giving you two
Or else
options.
possibly kindly take up the matter to tomorrow, Lordship.
Tomorrow I am not coming.
Oh, sorry. No, I mean on
Monday.
tomorrow means Monday.
Tomorrow means Monday. Monday
Means
is 2
when
days
the
away.
next working day, Lordship. The next working day.
Alright, Monday. The request made by the government advocate, matter stands referred to be listed on Monday, enabling him to obtain clarification as to why the PPP department had put the clarification contrary to the findings, contrary to the conclusions and findings of coordinate benches, different coordinate benches of this court, Gauhati and
9, my lord. Take justice service. Twice you have taken this. And answer.
You want to take Dusty? Petitioners are permitted to undertake service by your Dusty through the registry of this court. Let an affidavit of files to be filed. This is after the service is done. Mr. B. Bora for
7 and 8.
7 and 8 versus Roy Court. One, number 6 is as per one.
No. Item number, next item.
Who's for respondent 6?
Art.
Hard. Next matter, 1 to 5, as per. Same one. List after 4 weeks. Yes.
All right.
Affidavit filed, not filed.
Copy have been sent to the lordship and need to be filed today today.
Mr. C.K.S. Barua submits that affidavit will be filed in the course of the day in advance copy will be served. Straight after 3 weeks. You want to file rejoinder?
Yes.
Then you file it, then pray for a day. Mr. Barua for Mr. Henry Good.
1 and 4.
Within 1 week, my lord, I will file.
After we listed after 2 weeks, 3 weeks. 22nd.
Filed by government and
Lordship, in this case, I am appearing for the Union of India. The problem we are facing, Lordship, they are claiming pay parity and the Ministry of Finance is not make a party. And MHA is a party, but the finance is not a party, Lordship. We are having some problem to get the instructions. They are claiming pay parity. Lordship.
yeah, appointed under this department, madam.
That's why, Lordship, Department of Finance, there's a financial implication is there. Lordship, Ministry of Finance is necessary party.
NADM is the party.
Lordship.
The NAD Finance Ministry is the party.
Because they are claiming
That
Pay
yes,
parity.
The parent department under which we are appointed, madam, there is a party.
Huh.
And they agree to that, all these questions come, madam, otherwise this department takes decision, everything, madam.
Even if-
they
What
take
are
the
you
decision,
asking for? Parity?
Yes.
Parity, madam.
Who is to make the payment?
Madam, that
Finance.
this has to be granted by the parent department under which we are appointed, madam.
Mr. Council.
These are technical, madam, they are not
Not
provision, they have
technical,
taken time and now.
But if they say that the instructions are not forthcoming because they are not aired as a party, what stops you from airing them as a party?
But that is not a difficult. The problem is, my lord, my submission is that the department under which we are working, my lord, they granted, there may be many departments involved in the process of giving money to us, my lord. Then all the department may not be necessary party. The parent department, my lord,
All right, you file your affidavit if you have to. You're taking it. Up to the respondents are granted 3 weeks time to file their affidavit.
Lordship, then 4 weeks.
4 weeks. That will be listed after 4 weeks. Mr. Each of you would go.
they have to pay for a date, my lord.
22nd. May. 22nd will not be 4 weeks. 29th.
Lordship. Okay.
Number 5 has filed their affidavit and also admitted that the service of the petitioner has been regularized, Lordship, on 12 to 2004.
Affidavit today.
Mr. D. Barua for the petitioner and Ms. Kemprai for the Karbi Anglong Autonomous Council who submits that we have 5 minutes of the day. Matter stands deferred. Be listed after 2 weeks.
Lordship, he is going to retire on 31st of May 2026. And
There are
therefore,
2 weeks.
the honorable court in the transcript Lordship, can it be on 30th of April, Lordship? In the meantime, I will file a rejoinder. Otherwise, you will be prejudiced to release the pensionary. Regularization of service.
30th of May. As it is submitted that petitioner is retiring on, superannuating on
31st of May.
31st of May. Rejoinder, if any, shall be filed before that.
30. 30 or 30.
30, 30.
Can it be
You wanted 30.
30?
3, 1, 3.
Yes.
One, 3.
Yes.
Why? Anything special on 30?
Unless and until this honorable court will decide the entire matter, the department cannot process for the pensionary benefit of the.
So that we know. Not something that you have enlightened us about facts that we don't know. Of course, we'll have to decide. Only then the department will take. We also know how long the department takes to decide, in spite of order. We are asking you, since you expressed urgency, that your client is retiring on 31st, we thought you had prayed for 30th of April. But you want 13th.
30th of April. 30th of April.
30.
Yes, sir.
You're sure?
30th of April.
You're sure it is a good day for you?
On 30th of April, I can, in the meantime,
No, 13th of April is gone. 30.
30th of April.
30th of April. 30. Based on 30.
I live.
Bora for respondents.
I live.
Technician for assistant cases, minor. Partner, minor, the petitioner, minor, the successful to appear in the skill test also. But when the results were declared, except the petitioner, all the names of all the minor, the other candidates appeared. RTI.
Yes, health.
Lordship, similar matter, Lordship, we have filed our affidavit, Lordship, stating the.
When is it fixed?
Lordship, I'll give the details after some time, Lordship. The date is not fixed again, Lordship, but I can give the details.
When is the matter? What is the number of the matter? Each matter.
This is of 2020.
So is this matter?
Yes. I'll furnish the details.
representation that wasn't taken care of it, and earlier transfer order has been set aside and now been transferred to 34 Battalion Nogam. So I think he's happy with that.
The battalion is of Nagaon, but the company is posted at Manipur.
But the earlier order is recalled.
Yes.
You are agreed to challenge the new order. It is submitted to the bar that the earlier order of transfer has been altered, and now the petitioner has been transferred to 34 Battalion. Stop. Order was issued on 6. Copy of the same is furnished by the State Council. Stop. Petition counsel for the para council would not speak the contention against. Accordingly, further claim required to be decided. Present petition dismissed as pressed. Petitioner is press transfer order. Dispose.
Awesome.
Yes, Lordship, 2 weeks more time is required.
Huh?
2 weeks required, Lordship, for.
Mr. J.K. Goswami, learned State Council, prays for
Standing
further few weeks' time. Complete his instruction, there may be no next again after 2 weeks.
Wait, is it? Mother, 3 repetitions are listed before the lordship. First one, the transfer of. Second one, the decision to go for de novo inquiry. And third one is the repetitions where I challenge multiple proceedings initiated against me when the committee, under the motion has given lack of evidence. On last occasion, watching the issue notice for consideration of injury. However, one difficulty may remain. The health department has filed an affidavit. I presume it's not on record. But that might be required. Yesterday, it was copy was served.
My lord, we have also received the instruction, not the lady is free. That's why we could not file it, but by a week's time we file it.
So far as their affidavit is concerned, it's okay. But since I am praying for it.
No, we are praying for filing an affidavit because I am a
Correct.
necessary party.
Let me file an affidavit. But so far as the.
You want to file a rejoinder?
No, I would address on the interim, but without an affidavit on record
Right.
for lordship's consideration, Otherwise, she is, I mean, my friends.
Yeah, who's for health department?
Dipankar, Bora was hearing for the health department. I met him in the morning. I would pray for Monday because I'm praying for the interview. Only that has to be on record.
Heard. Mr. Bonik submits that health department has filed an affidavit. Which stop. Say the affidavit how we file it. Connected to the case report. Mr. We are respondent 7. Mike. Mr. Department. Mr. Anyone else? Respondents, private respondents are also permitted to filing the same. Since Mr. Bonik made urgent prayer for listing of the for consideration of the interim prayer, matter be listed on 27. 27.
Obliged.
After it be listed on 27 for consideration of
Lordship.
Obliged.
at the finance, my colleagues were supposed to file affidavit. Sir Borpujari informed, he's in another good manner. He informed me this morning that they have already prepared an affidavit and filing in week.
They're paying for a similar order method.
Oh.
For minimum scale of pay method, the earlier occasion after hearing method, they have stated before the court that one IA was filed and paying an appeal against that order. But the conduct IA for IA 719.
Pull up it.
About 2 and 15
They're asking, they're praying for
Leave it encashment.
leave encashment.
Gratuity and installment.
Yes, respondent.
Also, we have filed one affidavit on behalf of respondent number 1, explosive concern, when one extract out of finance department was been attached, that is at page number 45. What it says, Lordship, Srimanto, basically these are the employees under the Srimanto Hankar Kolakatra, Lordship, which is a society, and employees draw salary from grants in days. They are not basically a government employees of the cultural department. And Lordship, and they get on their own funds, Lordship. And hence there is no applicability of great pay in case of remuneration drawn from grants in aid. And the matter may be decided by the executive council of the society, and finance has no views to. Basically, it's a society versus they.
Who's for the society? Who's appealing for the society?
I think I've seen him once appear on behalf of the Kolkata.
Call him, call him. Call the council.
Against former, liable court.
Huh? The last order, Mr. Goswami had appeared. It recorded his name. It recorded his name. J.K. Goswami.
On time, image of the petitioner number 2 and their family has
Receive.
my lord, one monitor Momo, other person.
Lordship, so far, Lordship, the statement of the finance department, it's the society, Lordship, they will not get the.
No, you are not instructed. He is given some chart to show certain amounts have been paid for leave encashment in respect of certain other employees.
Yeah. that lordship, it is required to take steps.
That is what we permitted you to do last occasion. What are your instructions?
But this fact, lordship, it is 12 to 20.
Mr. Borgmai, then counsel.
And
appears- Huh?
and
M. Borgmai, sorry, appears for the petitioner. And Mr. J.K. Goswami appears for respondent 2, 3, and 4. Mr. Borgmai submits places before the court the particulars of certain payments made to employees or their former employees.
my lord, it is not 2 and 3, but 15. It is not number 15 and
The petitioner, what is the name?
Monasor Bomo.
Huh?
Untimely demise, my lord. It's not number 2 and 15. Their family.
One is Monesor Brahma,
Monasor Bomo and Gopal Sharma.
Pal Sharma. Petitioner number 2 and
15.
yes, please. And who are the others? Other employees?
My lord.
Sir, he has placed particulars of respect of employees, deceased employees of Mr. Bora therefore submits that this benefit which is claimed by the other petitioner should also be considered and released by the society. Mr. Goswami, on the other hand, submits that the instructions are not available to him. So it's time to obtain the required instructions. This matter be listed again after 1 week.
My lord, date
On 4th of May.
Right.
4th May, Mr. Goswami may not be available.
Lordship,
Yes? No,
lordship, before that or
before that. 29th, can you get it?
lordship, I will try.
29th.
Fine.
April. 1.
Lordship, the writ petition number is 7287 of 25 and it is fixed on 29/4.
It is submitted by Mr. D. Upamenyu that an affidavit has been prepared to be filed in respect of WPC number.
Lordship, there we have already filed 7287 of
Affidavit has been filed in WPC
87.
7287 of 25.
Yes.
The issues raised in the present writ petitions. So there are similar to the issues raised in the said writ petition. We therefore submit that these two writ petitions be listed together with WPCs also, so that matters can be decided. And the respondent be permitted to rely on the affidavit filed in the WPC number so and so. That is your submission?
Yes.
List accordingly. Since the department has submitted before the court that they would like to rely on the affidavit filed in WPC so and so, copy of the same is directed to be furnished to MS Chaudhary in 2 days, 2 working days. List accordingly on 15th of May.
Of like
retired employee corporation, some area is pending. We paid, that is admitted by the by filing affidavit, my lord. Page 18, but earlier occasion.
Page,
my lord, running page is 73, my lord, para 8 of their affidavit.
right.
Regarding entitlement, there is no dispute. Only thing is that because of financial phase, they done not.
But they had denied certain contentions. What is that denial?
Denial is that regarding area payment of the DA, what they have claimed. Others are admitted, that we have already paid, but the corporation, they are not admitted the area DA portion. They have not yet taken any decision to implement that hike, pay hike, as of now.
Then other dues you have received.
Yes, madam.
Well, other lead encashment and CPF that has got received. Only thing is that that they have, as they have
Areas
stated
they have
that
not-
corporation committed to sanction and release outstanding DA with effect from 96 to 2014 and from 2014 onwards. The DA, my lord, has not yet, my lord, released. Although they have portion of
No,
DA.
what is that denial? Denial?
Because there is no, the corporation, they have got a separate pay scale, accordingly they are being paid, and the existing employee as well as the retired employee, they have not been paid area DA, as and when the funds will be available, because funds are generated by themselves, they are not funded by the government. So as and when the funds will be available, they will make an endeavor to pay the area DA. But as of now, they have not taken it, the board has not taken it, pay the area DA. That is the stand of the corporation as of now. That is the contention of the, we have also stated that in our affidavit from para 5 onwards. Third on page 71. That is the stand of the corporation. Others, payment, we have already made the payments.
No, you are denying a release of area DA.
Yes, madam.
At the same time, you are saying that you are committed to releasing outstanding DA. What is the meaning of that? Contradictory.
They will make an effort to make the payment as and when the funds will be available.
What we are asking you, you are in your paragraph 8, you are saying, well, denying the contentions.
Yes.
What is that contention that you are denying? Para 8, 9, 10, 11, what is that? Let us see.
Yes, madam.
Okay. You don't deny their claims of area DA.
Yes, madam. They will get it, but as of now, because of financial concern,
All right.
we
So
cannot
how
make the
much
payment.
time? How much time is expected?
Because
3
they,
months.
no, they have to generate the funds from their own sources. And as of now, the concern is
Why to pay DA? Why adoption of the rules? Here you can't make for a fictitious claim that as and when funds will come, pay you. It's a part of the salary.
At least they shall calculate and inform that this portion
You
will
have
be
to give
released
some
and this
time
portion
frame
will
that
be
within this
later on.
particular time frame, like clear the deal.
because they have not yet made that calculation. What will be
Yes,
the,
my lord.
Who will make that calculation?
they will give an
Corporation.
application. They will give an application to the
No,
corporation.
no,
No,
application is
you
pending.
give the calculation, bring it to
Application
the-
is pending.
You take a calculation. Regard to at least the
Because
petition.
finance and account officer will
And then
calculate.
we know the position, how much DA they are paying for. How many petitioners are there?
I think 7 petitions.
Yes, my lord. 7, no, 9 petitioners, my lord.
Right, so in respect of these
Always
9 petitioners, the calculation as per the department.
Because the calculation has to be made in respect of all the retired employees as well.
It's all right, but these employees you can do it because you are not giving us any. You see, DA is a part of the salary.
Yes.
You can't say that no, not give you as and when until and unless we get the fund. Either you say that all right in respect of all employees, including the petitioner, the amount required, X amount, and we have X minus 2 or X minus 3 amount available. Rest as and when get it in 6 months or so. Get it. Some specific.
Let me take the instruction from the calculation from
Somewhere in
Is it on 6th May or
It
later?
will be in the last week of May.
Last week.
Yes, because the financial officer he's mostly on leave. He's doing his MBA also.
We're not concerned. We are not averse.
Let me get the foreign student.
Earning their education. List it on 29th of May.
Yes.
By which date the respondent authority write before the amount of DA, including area DA, to be paid to the petitioner and other sentences person. Then the process by which they would like to clear the outstanding amounts.
Okay.
Based on 29.
Awesome.
This, as per last order, where to file an affidavit that has been sent for waiting in cell, will be able to file by next week.
Mr. B. Chakraborty, Learned Standing Counsel, Accountant General, submits that affidavit. The process of being filed is likely to file the affidavit within 1 week, by next week. Mr. Boro, counsel for the petition, not objecting, prayer made against B. Bora, appeals for BTC. Mr. Dhor, you're also there? Mr. R. Dhor for respondents 1 and 2. Has prayed for, that will be listed again on 15th May. Not 12, then 13. 13. By which date? The
I've sent affidavit for waiting. I'm in a week's time.
Same paper to be listed after 3 weeks. By which time the respondent will file the affidavit. Of liberty is also granted to the petitioner to file rejoinder. Such an affidavit is filed with this. Prayer made earlier will continue.
Matter, I have a inspection from the MD of the corporation manager. They have calculated some how much they have paid and what is the balance. But they say that this moment they don't have money, and because of this model code of conduct, they were supposed to get some grant in it. That also didn't work out. But they have, as an interim, they have paid all these 9 petitioners 50,000 each during this bihu. And apart from that, my lord, there is a list of how much they have already paid. Disbursed, my lord. So, my lord, let me bring this everything on record, my lord. And in the meantime, my lord, there is a 2-page instruction, my lord, from the MD. This is what they have paid, and they have accepted that this is their balance.
How do you intend to clear the balance?
My lord, that is what in the next page, my lord. They said that this moment they were waiting for some grant in aid. And because of this,
Is it non-functional?
my lord, after COVID, it's almost like long functioning, my lord.
What is the, how do you earn your revenue?
My lord, handloom product selling, handloom product. My lord, let me bring from the.
This is not something that should be done. You are selling indigenous products. Let's make all attempts to revive.
My lord, handloom even trying very hard to, my lord. That's why handloom always give them grant in it. But my lord, somehow, my lord,
So do you only sell or you give benefits to handicraft? The
no,
wares and
my lord, this is only marketing.
only market
Only marketing.
of the products.
Of the product.
It's difficult unless you say that this has happened because of the lackadaisical attitude of the employees themselves.
My lord,
When can you find it?
my lord, I will file. My lord, my prayer, once I file it, my lord, can pass an order, my lord.
So we can pass an order, but the question is how do you intend to implement this order? See the figure which you are required to pay.
Yes, my lord. Because that,
Even if we give you 5 years, you will not be able to complete. First come up with a realistic
my
plan.
lord, that is what the management told. That at this moment, there is no government functional, at least. Because, my lord,
The government may not be there, but there must be some suggestion, plan of action
plan of
thought
action.
about by the officers of the
plan of
corporation.
action, my lord. They told me that they have drafted a proposal. They will go to the government. And they need to pay. So somehow that is the plan, man.
These things we have to stop. You can't keep on going and ask for money from the government all the time. You're a corporation. You're a public sector undertaking. Why we are not able to have a plan of action, proper workable plan of action for generating funds? That too a marketing corporation.
Let me find a affidavit.
Mr. Ardhor, standing counsel for the corporation, submits that while the corporation does not dispute the paying of the corporation, certain amount have already paid. Therefore, like to bring forward by to the passing. Mr. Ardhor, 29th of May.
And it has also been instructed to me that in case it would not have been created to the account of the bank in the petitioner, these would have been that reverted back to the DDO. But there would be a change.
You get your correct information.
And my lord, that after 12:30, I made a phone call to my client. He told me that no money deposited as of now in his account.
Verify.
They can bring the bank statement.
Mr. I.A. Talukdar, counsel, submits that amount stated to have been released by the petitioner. Respondent authority does not use. The course will obtain instructions and produce bank statement, bank particulars to show that the amount has been credited to the account of the receipt.
That the petitioner may
You also have a bank account.
Actually, we send it to the treasury. Be feasible for the petitioner to bring the bank statements.
You produce a bank statement.
Yes.
The respondents, respondent petitioner will produce a bank statement in support of suspension based on when. When can you produce?
My lord, on it's 16 or 17.
On 18th. 18 May. Yes.
Application, these matters, you will find a reply. Madam, I have come to know that the state has pressed a read appeal against a very specific order of a very single judge, which we deny. It's minor under last occasion, I had for time minor to file an affidavit, counter affidavit on behalf of the finance department.
Yes.
But I am awaiting the instructions they are furnishing, they will be furnishing me minor within a short time minor. I am seeking some accommodation minor of at least 3 weeks minor to file my counter here. And they have relied minor in the petition, they have filed minor one minor additional affidavit whereby they have brought on record minor the judgment and order dated 5/10/2023 passed by the Honorable Court minor in WPC 7131 of 2021. That lordship will find my lord
Page
at
one.
page 68, my lord, running page 68, my lord. Now, this is the order whereby my lord, the
Some appeal has been filed.
yes, my lord, the petitioner
That is, what I, the year past, the year 2000,
lordship will kindly
but
see this.
actually they have prepared only 26 minutes. And they have not been considered. The IA for convention release 719 of the 2006. Delay,
That
delay,
is-
their delay
That is-
not considered.
That is the order. Now, here, my lord, the
We have
petitioner
Fixed on 29/4.
29/4.
Right?
Yes.
Then matter be listed again.
After
Matter be listed again on.
I can be accommodated, my lord, with all respect for 3 weeks. My lord, in the meantime, I will
Why
file
are
an
you taking
affidavit
3
on
weeks
this.
time to file it?
My lord, they are processing it, my lord.
What is there to process? Whatever is there, you file it.
My lord.
You can't, they say that the position is similar to what was decided by court
So
network.
that is one aspect of the matter,
No.
but on merits, my lord, I am making a prayer, my lord, to file an affidavit.
File it, we are fixing it on 13th
13th of May, my lord.
May,
My lord.
13 May,
Yes, my lord.
by which date the respondents, the finance department, may file their affidavit. So
So obliged.
it is also submitted that the judgment and order dated 5/10/2023 passed in WPC 7131 of 2021 has been appealed against by the state, where the matter is pending for condonation of delay in IA Civil 719 of 2026. Stop, the matter is fixed on 29/4/2026. Counsel for the at the bar will apprise the court on the next day regarding the status of the pendency of the file.
And so obliged.
Need some further time, my lord, to file our affidavit from the PWD. We are yet to receive any instructions from.
For appointment of an arbitrator. There any objection that there is no dispute? That's the only
My lord,
information you require.
my lord, that is what, my lord, we are awaiting from our department manager.
Mr. A.Y. Chaudhary appears for Regularization. And Mr. Ardhor, Standing Counsel for the department, PWD department. So Mr. Dhor submits that his instructions are awaited. He prays for 2 weeks should be enough to find out. It's time to obtain his instructions. Released again on